Hello everyone and welcome to the MW Partners and EmploySure webinar. We are pleased to welcome our presenter for today, George Michael, co-host Albert Geigel and representative of EmploySure, Richard Shaheen. This webinar is live and interactive. You are encouraged to post questions to the presenter throughout the presentation. If you're experiencing any technical issues during the webinar, please dial our support team on 1-800-733-416. This number is also listed in the chat box. I'd like to now pass you over to Albert and Richard to begin.
Hello, my name's Albert Geigel from MW Partners Special Dental Accountants. We have offices in both South Yarra and Victoria, as well as the Gold Coast in Queensland. And even with a team of 5 specialist dental accountants, we often find that questions relating to payroll need to be referred to an organisation that specialises in payroll matters. We are pleased to bring you this webinar in conjunction with EmploySure, who have assisted many of our dental clients over the years, as well as being the advisor for all payroll matters relating to employees of MW Partners. I'm sure you'll find the following presentation engaging and informative. I'll be online for any questions at the end of the session. And so now I'd like to pass over to Richard Shaheen from EmploySure.
Thank you, Albert. Hello, everyone. My name's Richard Shaheen. I'm a representative for EmploySure. If you haven't heard of EmploySure, we are Australia's leading expert when it comes to workplace relations. We've got over 18,000 clients, and we've been very fortunate to co-present today's event primarily on workplace relations. So, folks, today's session is really an information session, an opportunity for you to understand your obligations, responsibilities, best practices when it comes to managing your staff in line with fair work. There'll be a couple of areas covering WorkSafe as well, in line with the Occupational Health and Safety Act. I'll be co-presenting also with my colleague, George Michael, who will be presenting a lot of the content today. I'd encourage you to ask questions. There's a box on the bottom left-hand side. If you've got any questions that come up as we go through the slides, please type them away and we'll endeavour to go through them one by one. This segment should pretty much wrap up within the hour, so I'd like to pretty much hand it over to George.
Thank you, Richard. Good afternoon, ladies and gentlemen. My name is George. I'm a consultant with EmploySure. My role is to meet with companies and conduct a full compliance review of their workplace relations to ensure that they are meeting their obligations in line with the Fair Work Act and any of the modern awards or any other industrial instruments that apply to their business and to its employees. As part of my role, it's to do a deep dive to ensure that businesses are meeting their obligations in line with minimum award rates, base rates of pay, everything from allowances, loadings, etc., and the several nuances that businesses need to ensure they're on top of so that they're mitigating their risks in line with any underpayments, but also providing advice around unfair dismissals, adverse action, and the general problems that businesses do encounter with managing employees. What we'll cover today is the importance on contracts and policies, but we'll also cover unfair dismissal and adverse action claims, which I'll explain a little bit on as we go through the presentation, but we will commence with regards to the modern awards that apply specifically to dentists within the health and allied services. And if, as Richard mentioned, if there's any questions that you have, please pop them into the box down below, and I'll endeavour to answer any questions either verbally or respond back in writing as well. All right, so what we're going to go through today is, as I mentioned, the specialist health industry, and what I really want everyone to get out of today is to learn more about the types of employment, that being contractors versus employees, the hours of work and allowances that employees are entitled to, and also on managing difficult employees as well. All right, so some information here. The Fair Work Act provides basic entitlements to employees, and that includes leave entitlements, and also protection from unfair dismissal and adverse action. The most common award for dental practices is the Health Professionals and Support Services Award, which sets the minimum employment conditions for this specific industry. As many of you would already know, there is no award that actually covers medical practitioners or dentists working in a general private practice. There is also the Medical Practitioners Award, which covers medical practitioners working specifically for hospitals, hospices, benevolent homes, day procedure centres, and Aboriginal health services. The purpose of this slide is to make you aware of the rules and regulations of the industrial relations system, but it is really a complicated system. And what we'll also be covering today is on some basic employee entitlements such as leave, protection from unfair dismissal, bullying and harassment, and adverse action, as I mentioned. Now, Australia has one of the most complicated employment relations systems in the world. The Fair Work Act, it does provide a safety net of minimum entitlements for all employees. It also provides for basic entitlements, as I mentioned before, for leave accruals, protection from unfair dismissal and adverse action. But more specifically, the modern awards set minimum conditions for the employees covered by them, and that includes base rates of pay, ordinary hours of work, penalty rates, allowances, and these are matters which can have a significant impact on how you plan and run your business. There are over 120 modern awards in Australia. So where does a business start? Modern awards are industry or occupation specific, and often multiple awards will apply within one workplace and across multiple employees and their roles. So establishing award coverage and classifying employees under awards is not clear cut. And if you do get it wrong, you could end up with underpayments or in some cases overpaying employees, which can also be a significant impact to your business. And also, end up with fines and penalties as well, which I'm sure that every business owner wants to avoid. So the common industry awards in the health industry are the Health Professionals and Support Services Award, the Nurses Award, the Medical Practitioners Award, but also, very interestingly, possibly the Manufacturing and Associated Industries and Occupations Award if the practice makes orthodontic products. So you can see right there that there could be multiple awards that apply to the business, but of course, depending on what your actual business does. So as I mentioned, it's a very complicated system, and often employers require assistance to understand their obligations. The Fair Work Commission recently published a survey of small business owners regarding modern awards, and the findings were quite interesting. So some of the findings that came out of this was that the small business owners survey, of those who actually were surveyed, being small business owners, found awards to be daunting, difficult to use, complex and challenging, and without any consideration for their actual needs. The language was convoluted, vague, and full of legal jargon. So it requires expensive legal advice to understand and interpret them. And really, it's a luxury most small businesses can't afford. It also, the survey also found that owners struggled to identify which award was most relevant to their business, and they could not understand the application of penalties and other additional payment provisions. These are all common issues raised by our clients as well. An example being the fact many awards contain provisions in various different parts of the award, such as those relating to breaks and overtime. The difficulty in understanding the modern awards resulted in owners paying above the base award rates in the hope that this would cover any additional payments and penalties due under the award, or even looking at contract labour to avoid the issue, such as labour hire or engaging contractors. Being in the industry of human resources and employment law over the last 15 years, and being a senior consultant at EmploySure, I can most definitely say that 15 years of worth of having to go through modern awards and understand and break down that legal jargon has definitely been a challenge, but something that Employsure hires highly skilled consultants like myself to assist business owners with respect to understanding what their legal obligations are. All right. We've touched on contractors, or we will touch on a little bit about contractors. It is very common within the dentist industry that you engage your dentist on an independent contracting basis. Of the hundreds of dental practices that I've completed compliance reviews for, I find that probably a good 90% of owners will engage dentists as contractors, or if they are engaging them as employees, then they are indeed award-free. So what is the risk of sham contracting, or what are the risks involved with respect to engaging contractors versus employees? So the Act provides serious penalties for contraventions of the provisions of contracting. The courts may impose a maximum penalty on a business of $54,000 for a corporation, or $10,800 on an individual per breach basis. The following are considered breaches under the Act, and the Act does specify misrepresenting an employment relationship or a proposed employment arrangement as an independent contracting agreement, where you either dismiss or threaten to dismiss an employee for the purpose of engaging them as an independent contractor, or making a knowingly false statement to persuade or influence an employee to become an independent contractor. I would like to focus more on the first bullet point, because that's where the majority of sham contracting actually happens, whereby certain businesses will either misrepresent an employment relationship and disguise it as one of a contracting relationship to avoid having to pay the worker certain entitlements such as leave, superannuation, and then just the base rate of pay in line with the actual award. When we're looking at contracting versus an employment relationship, there are many factors which will the Commission will determine of whether the relationship is genuine or whether it's more of an employment relationship. To summarise that, part of my role is to ask a series of questions to business owners with respect to how they're engaging their contractors. And that could be anything from how often are your contractors working for you? Are they working for other parties? Are they solely just providing a service just for your business? Do they have their ABNs? Do they have specific insurance policies such as public indemnity, work cover? If they do you have a copy of their certificate of currencies? Are you providing them with all tools and equipment? Do they have to wear a uniform? Are they required to comply to your processes, rules and regulations? Are you providing them with motor vehicles? And are they able to subcontract out the work? And I find that if a lot of the answers to those questions are no, or in some instances, yes too, my apologies. So, yes, we've got contractors and they can only work for me. They're not allowed to work for other parties. They're deriving 100% of their income from me. And they're not allowed to subcontract out any work either. They must wear a uniform. They must start at certain times, work X amount of hours throughout the week. I provide them with all tools and equipment. They're covered under my insurance policies. Then that's where there is potential concerns of risk sham contracting, whereby what I've just explained now does actually constitute more of an employment relationship than an actual contracting relationship. With that end, though, Employsure is able to assist clients with respect to either refining, finessing, or tidying up the contracting relationship to make it more genuine, and then by that also providing legally compliant and fully up-to-date independent contractor agreements, and ensuring that the business is actually treating the contracting relationship in line with the independent contractors agreement that we provide. Or we work through with businesses with respect to engaging that contractor as an employee. In the instances where a contractor declines an employment offer, which is actually very common within the dentist industry, then we provide additional documentation that will serve as a strong asset if that person was to then raise a sham contracting claim at the Commission. So there are a few ways we're working about it, but understanding your legal obligations and avoiding such penalties as $54,000 and $10,800 on an individual breach is very important, because you obviously want to reduce your liability with respect to contractors. Then if I look at the flip side and we talk about engaging employees and go back to the Health Professionals and Support Services Award, the award covers employees in the health industry, and it also covers dental practices and their employees in the classification set out in the award. There are two streams under the award with respect to classifications, and that is you have your health professionals and then you have your support services. The health professional streams, you will only find your dental therapists, and in the support services stream, you'll find roles such as dental assistants and dental technicians. So your dentists and your dental hygienists will always be award-free. A lot of dental practices will, of course, have receptionists or administrative staff, and they will fall under the support services stream of that particular award. The award also covers employers engaging a health professional employee falling within the classification set out in the award, or an employee who provides support services, as I mentioned. So hence, the award provides for both industry and occupational coverage. An employer may direct an employee to carry out such duties that are within the limits of the employee's skills, competence and training, consistent with respective classification. And, when you're looking at classifications, you're looking at level 1, 2, 3, 4, 5, 6, 7, for example, it continues on. And then ensuring based on how many years and what qualifications the employee holds is a matter of Employshore assisting its clients with ensuring that they are classifying their employees under the correct levels of the award, and as such paying them the correct base rates of pay, including any overtime, penalties, loadings and allowances which may otherwise apply. Over onto the next slide, I'd like to get into the definition of the different types of employment. So under this award, an employee will be employed in either one of the following categories, that being full-time, part-time and casual. At the time of employment, an employer needs to determine whether that employee is full-time, part-time or casual. A full-time employee works 38 hours per week plus reasonable additional hours. They accrue 20 days of annual leave and 10 days of personal leave. A casual employee must be engaged for a minimum of 2 hours per shift and is paid an additional 25% loading on top of the base rate of pay, in lieu of not actually being entitled to receive annual leave and personal leave entitlements. Interestingly enough, though, the award contains very specific and strict guidelines regarding engaging part-time employees. So, for example, the award specifies that before commencing employment, the employer and employee will agree in writing on a regular pattern of work, including the number of hours to be worked each week, the days of the week the employee will work, and that includes the start and finishing times of each day. Any terms of the part-time agreement that are varied, that agreement must be recorded in writing. And this is where it can sometimes get a bit complicated. And what I find on a daily basis is that, when you engage part-time employees, it's usually a regular pattern of work for a guaranteed hours of, let's say, 20 hours per week, because a part-time employee works less than 38 hours. As you know, there are busy times and you may require your part-time staff to put in some extra hours in excess of the example of 20 hours. So wherever a part-time employee is required by their employer to work in excess of those agreed hours, they are technically entitled to overtime in accordance with their classification under the award. However, most employers in this industry are unaware of that and continue to pay that part-time employee their normal base rate of pay or their flat rate. Employshore can actually assist with respect to advising you that it is legally compliant to continue to pay a part-time employee their standard rate of pay for working outside the agreed hours rather than overtime if the employee has actually consented to do so. And it's important to get something in writing, which is documentation that Employsure does prepare that will assist you to meet your obligations and to protect you for any liability costs for overtime. I have just received a question and I just want to have a quick read. 2 moments. Okay, so Chad has asked, if purchasing a practice which has an associate dentist working as an employee, is it a breach to request the associate become an independent contractor after sale of the practice? Okay, so to me that sounds as though you've purchased the practice, you've got an associate dentist who's working as an employee. It's an interesting question. So where you've purchased a practice from a previous owner and there's been a transfer of business, if you have engaged that associate to continue on as an employee of the organisation, they've obviously transferred along with you in terms of an employment relationship. There is a way of looking at it and saying, well, technically by law, you're not obligated to actually take on the employees from the previous owner. So it would be a matter of that owner making that position redundant. You haven't taken them on. Technically, you could engage them as an independent contractor. You would just need to ensure that the way that you're engaging that associate as a contractor is actually genuine, and that the relationship isn't one that's misguided to be a contracting relationship when in essence the nature of the relationship is one of more of an employment relationship. So just to summarise, yes, you can engage them as a contractor if they've been an employee previously. You've just got to ensure that the independent contracting relationship is genuine and that it doesn't potentially breach any sham contracting provisions. Okay. All right. With respect to going back to the award, the ordinary hours of work, there are 4 unique streams to the award. There's the private medical, dental and pathology practices. There's the private medical imaging practices, and then there's physiotherapy practices as well. Right? But today we will actually focus on the dentist one. There are weekend loadings with respect to the award, so Saturday and Sunday work. Although an employee may be permitted to work ordinary hours on a Saturday and Sunday, it is really important to check the award to ascertain whether any loadings are applicable. Specifically, there's a clause in the award, which is 26.1, that for all ordinary hours worked between midnight Friday and midnight Sunday, a day worker will be paid their ordinary hourly rate and an additional 50% loading. Now, it's not that common that you're actually going to be opening up a dental practice that's going to be open past midnight Friday up until midnight Sunday. But, you know, what it's saying is midnight Friday to midnight Sunday. So these are all the hours over the weekend period. So what the employee is entitled to of all the hours that they work is a 50% loading. All right, further to that, Saturday and Sunday work. So casual employee who works on a Saturday or a Sunday will be paid a loading of 75% for all time worked instead of the casual loading of 25%. So what that means is that any hours of work on weekends for casuals is not paid at an overtime rate. They are actually ordinary hours. It's just loading at 75%. And if you look to that slide towards the right, you'll notice that the work performed on a Saturday is paid at the rate of time and a quarter of the employee's ordinary rate of pay instead of the loading prescribed under the clause. Saturday and Sunday work Work performed on a Sunday will be paid at the rate of time and a half of the employee's ordinary rate of pay instead of the loading prescribed in clause 26. And then we're looking at specific ages as well. So if we just look at the example of a level 1 employee, let's say we look at the age of 18, ordinary hourly rate, Monday to Friday, $16.47. All hours worked on a Saturday or Sunday, $23.06. All hours worked on Saturday, if you are operating as a 7-day private medical practice, is $19.76. And then the first 2 hours of overtime, Monday to Friday, is $23.06. So what are the overtime penalty rates? So an employee who works outside of their ordinary hours on any day will be paid at the rate of time and a half for the first 2 hours and then double time thereafter. So what that's saying is that where you've got full-time employees who are engaged on a 38-hour basis, under the award, the full-time hours for the hours for full-time employees, 38 hours per week. Once they've worked in excess of the 38 hours, they are entitled to time and a half for the first 2 hours and double time thereafter. All overtime worked on a Sunday is paid at the rate of double time, and these extra rates will be in substitution for and not cumulative upon shift loadings. Then there are specific allowances that are governed under the award. And some of the most common allowances under the award, which may apply, include clothing and equipment, damaged clothing, meals, and on-call allowances. Then you've got everything from an employee using their own mobile phone, if they're on call, whether they're, there's a heat allowance, there's damaged clothing, there's travel, transport and fares, there's tools. So as you can see, there's a lot more allowances on the slide which may apply. At Employsure, we provide a breakdown of the common allowances and are on call to assist our clients to identify which allowances are applicable and payable based on what the employee is actually doing at that time. All right, then there's breaks. So under the award, there's meal breaks. So an employee who works in excess of 5 hours is entitled to an unpaid meal break of not less than 30 minutes and not more than 60 minutes per shift. There is a tea break that's applicable. It is a paid 10-minute break in each 4 hours worked at a time. And an employee who works overtime will take a paid rest break of 20 minutes after each 4 hours of overtime worked, if required to continue work after that actual break. With respect to the tea breaks, subject to agreement between the employer and the employee, such breaks may alternatively be taken as one 20-minute tea break. So rather than breaking it up for 10 minutes, 4 hours later, another 10 minutes, it can actually be taken cumulatively. Tea breaks do not count as timed work. Sorry, my apologies. Tea breaks do actually count as timed work, so they must be paid, whilst meal breaks are actually unpaid. I've just got another question. Okay, so if a dental assistant earns $25 per hour on a casual rate, how much should they be paid on a Saturday? So the loading there is, 2 moments, it's 75%. So if they're paid $25, a dental assistant who earns $25 per hour on a casual rate needs to get an extra 75% loading for working on the Saturday. We're going to move on now with respect to contracts and policies. I want to discuss the importance of having contracts and policies in your business and how they protect you. Time and time again on a daily basis, there are a lot of businesses in Australia across several industries that don't have contracts of employment. So there's that, verbal agreement or that gentleman's agreement, and there's also no policies in place which then assist the business with actually ensuring that they're setting the expectations with their employees. All right. A lot of the times I'll ask business owners, if you don't have any contracts in place, what do you do to rely upon to ensure that your employees know their terms and conditions of employment? You want to eliminate as much ambiguity as possible. So where a business does not have contracts and policies in place, especially contracts, a business is left with only the Fair Work Act and the awards. And the Fair Work Act and the modern awards are extremely employee friendly and not clear for your managers or for you to understand, or in some cases even employees. What about things which are not covered, which can provide additional protection for your business? And things that aren't covered in modern awards and in the Fair Work Act is confidentiality of information, intellectual property rights, when employment ends with respect to restraints of trade, restraining employees for working for a business that directly competes, and soliciting your clientele. So that's where contracts can definitely assist. So contracts provide certainty around your obligations and those of the employee. And I find that if you do not have a written contract, a contract will still exist between you and employee, being a verbal contract, but it will be based on the conduct between you and the employee and the previous custom and practice that has formed over time, which leaves the parties uncertain of the relationship and the terms are ambiguous. As an example, you may pay your employees above the minimum wages and not pay annual leave loading. However, you cannot offset payments above the award minimum rates of pay without actually specifying that specific term in the contract. So again, on a daily basis, what I see is that, especially in the dental industry, business owners will pay a little bit more above the rates in order to cover the leave loading. So the leave loading, or the annual leave loading, is 17.5% extra paid to the employee when they take periods of annual leave. And a lot of the times clients will say, there's no need for us to pay the leave loading because we're paying above the award, and that has been incorporated and loaded into their base rate of pay. That is perfectly 100% legally compliant and okay to do, as long as the amount that's paid extra is still absorbing that rate of 17.5% throughout the year. However, a year and a half ago, all modern awards, all 120 or 128 modern awards were updated to specify that where you are offsetting the obligation to pay the leave loading by increasing the employee's rate of pay to incorporate it, there must be an agreement in writing that actually confirms that. So the employment contracts that I provide to our clients who are paying above the rates to cover off the leave loading, I'll always enter a clause in there to just really make it clear and say annual leave loading has been incorporated into your base rate of pay, therefore you will receive no further payments of leave loading during periods of annual leave. It's not just the leave loading. We've got a lot of businesses who will pay sufficiently above the award to perhaps cover off the every Saturday that a casual employee might work. And that, again, is compliant as well, or whether it's a salaried employee. And that's okay as long as the employee is still receiving their minimum entitlement. Casuals are really, really difficult to manage with respect to putting in loaded rates. A lot of the times a client will say, I pay my casual, dental assistant, and this is just an example, $27 per hour. And that includes the 8 hours of Saturdays that they work and the 3 hours of Sunday. And their normal base rate of pay between Monday to Friday is X, Y, and Z. The next question would be, okay, do they work on public holidays? Yes, they work 4 out of the 10 public holidays that we've got. I'll then do a calculation and then say it's actually covering off the Saturdays and the Sunday rates, but you're only covering off 2 public holidays, not actually 4. So you need to increase that rate to actually cover you. And then also advise them of the risk of what happens if you decide to open up on more public holidays. Have you actually factored in that rate? And if not, then at least ensure that employee is going to receive the correct public holiday penalty rates on the day that they're actually working. With respect to compliance, when it comes to contracts and policies, having contracts ensures compliance with the statutory obligations. So for example, by ensuring you have issued the Fair Work Information Statement to all your employees as required under the Fair Work Act and meet other statutory requirements. So the Fair Work Information Statement covers the 10 national employment standards, and that, it has everything from how many hours a full-time employee works, what are the leave entitlements for full-time and part-time employees, from parental leave, notice of termination, redundancy, etc. And the 10th National Employment Standards is for all businesses to offer its employees a copy of the Fair Work Information Statement. Also, if there is no contract in place, then there could be assumption about reasonable notice if they're not covered by an award. And contracts also help to protect your business in the sense where it protects you, but it also protects your employees as well. So contracts are important to protect your business interests, as I mentioned before, through post-termination restraints, confidentiality clauses, the use of company vehicles, whether they're entitled to receive a mobile phone allowance, a vehicle allowance, or any company property, including mobile phones or iPads, etc. From an employee management perspective, they really do set the expectations. So by clearly communicating your expectations to employees, you maximize the chances of employees meeting your actual expectations. So most employees want to or will do the right thing, but don't necessarily know what the right thing is. If you can communicate this to them at the early stages of the employment relationship, it will set them on the right path and avoid bad habits forming, which in turn will make it easier for you to manage your employees. So you're meeting your compliance obligations, you're setting the expectations, but then there's the importance of actually enforcing them. So for those who may not wish to toe the line, you have set out clear expectations which you can point to if they're not complying with them and take action for misconduct. They give you a range of options to address an employee who is breaching either their contract or your actual policies and procedures. So by setting clear expectations, then you are in the best position to enforce them, and to reduce issues in the workplace, which in turn increases morale, productivity, and efficiency, as you and your employees can focus on getting on with the business rather than focusing on the drama which can exist in dysfunctional workplaces. Policies are extremely important because they're dynamic and they're discretionary. They're your HR policies. They can be amended without your employee's contract or consent, and an employee is not required to sign your HR policies and procedures. However, the employee handbook that consultants like myself draw up for contracts is specifically tailored to your HR policies and procedures, and also are written in line with the Act and the advice that you receive from our advice team, and they really do set the expectation and help you performance manage employees more effectively going forward. Contracts, on the other hand, are legally enforceable terms, so it's a legally binding document. It enforces the expectations, it confirms terms and conditions, and any variations once signed by both parties need the consent from both parties.
George, Richard here.
Yeah.
I wanted to just interject at this point with relation to contracts being legally enforceable and having business owners either draft them up themselves, make it up themselves, cut and paste it from Google, recycle it from other workplaces. We've both seen it in the field many times over. What's the challenge from your perspective that you see when a business owner goes about it that manner and wants to enforce it, and there's flaws or holes in their agreements and they don't stack up? What can be the challenge or recourse for a business owner if they don't get this particular piece right with managing their business practice and getting the most out of their staff, but also not having it being used against them?
Yeah, so it's not a legally compliant contract. If the terms and conditions of a contract which a business owner has either written themselves, as you mentioned, or gone onto Google.com and taken it from another business, if those terms and conditions are not compliant in relation to the Fair Work Act and to the modern award that applies to the business and the particular employee, then the risk there is that the business owner has actually breached the contract that they've issued to the employee. Should a claim come up at the commission or that contract is challenged in court. Hence, the contracts that we provide, Richard, as you know, are legally compliant and fully up to date. They are industry specific and they are in line with the awards for each specific industry as well.
Okay.
So the overall question there is that if there is a claim that an employee raises as a breach of contract and specific terms in there have been, entered correctly, then the business is obviously liable for breaching the contract. But with that said, you can have a legally compliant contract that's 100% up to date. If you're, as a business owner, not fulfilling those contractual obligations, you're once again breaching that contract. It can be sued in court, basically.
Right. What about if there's changes in the relationship or the conditions of employment? Have you found from your experience that sometimes they've got a legally binding agreement, but they're limited to making changes because they've locked their contract and procedures under one document and then signed off, and now they want to change the terms? Do you find that's been a challenge for many business owners in the past?
Yeah, I mean, look, we've definitely gone through some contracts where, there are certain terms in the contract which are better placed in a HR policy manual rather than an actual contractual term. It's in those instances where, myself and my colleagues will advise that such terms actually be removed from the employment contract and set up more as a policy and procedure. Therefore, as the business changes its needs and wants to change certain policies, they can do so adequately and freely via a policy, as it doesn't require consent from an employee. The challenge sometimes is that, I'll give you the most silly example, right? If you've got in a contract that, on Mondays, every employee must turn up to work wearing pink socks, and you then change your practice and think, well, actually we're over pink socks on Monday, we want to make those green. An employee can actually not consent to that and say, well, my contract actually specifies that I'm wearing pink socks on a Monday. You're then breaching our contractual agreement. Sorry, that was a really simple and a bit of a silly example, but having certain policies taken out of a contract and making them into policies is much better. You've also got to ensure, though, that where an employee consents to a specific term in their contract to be changed, you can still, as a business owner, be sued in court if what you've contracted out of is the Fair Work Act and the Modern Award. You can't contract out of the Modern Awards. Time and time again, there might be, not so much in the dentist industry, but, actually sometimes it even happens in dentistry where there's underpayments. And a client might say, well, the employee actually knows they're getting underpaid. They're happy with this because they're perhaps receiving Centrelink payments, or they're old and they don't really care as much. They just don't want to be spending too much at home. And we've come up with this agreement, even in writing, where we're happy to pay, $2 or $3 under the award. And by signing that contract, well, then that's okay. I can't get sued in court. Well, the answer to that is they can still sue you if they wanted to, because you are actually paying less than the award, and the award makes it very clear, as does the Fair Work Act, that you can't contract out of your obligations.
Yeah.
Any other questions, Richard?
No, that's all.
All right. Might just move on a little bit quickly now, just to get onto poor performance and unfair dismissal. All right. So we've talked about contracts. We've talked about the general provisions of the awards and how they apply. So they're the two, one of the two biggest things, that impact businesses. But then we're talking about unfair dismissal claims as well. So in order for a dismissal to be successful in court, at the commission or a court or tribunal, an employer needs to have a valid reason. So was it due to poor performance or was it due to misconduct? We'll be talking about what is a protected employee and ways on how to actually avoid a claim. So another key risk on termination, but also one which needs to be considered at all stages of the employment life cycle. So all employees and even prospective employees are entitled to protection against adverse action if the reason for that action is a prohibited ground. Actually, sorry, my apologies. Just go back. All right, my apologies. So let's start this again. So we've got a person who's been unfairly dismissed. And when the Fair Work Commission is satisfied that the person has been dismissed, the dismissal was harsh, unjust, or unreasonable, or where the employer is a small business, the dismissal was not consistent with the Small Business Fair Dismissal Code, then that employee will win that unfair dismissal claim. So an unfair dismissal claim, a person or an employee can make an unfair dismissal claim if they have completed the minimum employment period. So for businesses that engage more than 15 employees, a business has up to 6 months to assess their performance and conduct. And if they're not meeting their expectations, they can dismiss the employee and the employee does not have protection or access to unfair dismissal. Where a business operates fewer than 15 employees, then it's within that 12-month period that they can terminate and an employee does not have access to unfair dismissal, generally. A person can also make an unfair dismissal claim if they are covered by a modern award or an enterprise agreement, and that it specifically applies, to their actual job role. Employees have to apply to the Commission within 21 days of the dismissal taking effect. The 20-day period starts the day after the dismissal, and the employee can only claim 6 months of their wages. So the main thing is a dismissal will be deemed unfair unless it is a valid reason or it's a genuine redundancy and a fair process has been followed. And what the Commission will always look to is, was the reason fair, reasonable and just? From here, we'll touch on adverse action and discrimination. So when it comes to adverse action and discrimination, all employees, including prospective employees, so someone who hasn't even been given the role to join your organisation, so this is even candidates have access to adverse action, are entitled to protection against any adverse action if the reason for that action is based on a prohibited ground. Right, so when we're looking at prohibited grounds, we're looking at things like race, colour, age, disability, family or carer's responsibilities. In the event that I was going for a job interview and they asked me, I don't know, I'll give an example, are you a smoker? And if I said, yes, I do smoke, and they said, well, sorry, we can't employ you because we don't like smokers in our organisation, I would be able to raise an adverse action claim, believe it or not. Right? And then it also happens throughout the employment life cycle. Staff can raise adverse action claims because they weren't given a certain promotion based on how it was carried out with the business. Or, I wasn't given a promotion because I can prove that the reason why you didn't promote me is because I just told you that, I've just fallen pregnant, as an example. Adverse actions are quite a big deal because penalties and remedies are incredibly broad and can include interim injunctions to prevent action, reinstatement, and uncapped compensation. As I mentioned before, an unfair dismissal claim, an employee can only claim 6 months of their wages. With an adverse action claim, it's uncapped. So, they can go for gold, basically. Also, the onus reverses. So the employer has to prove the reasons for the action and not prohibited, and the prohibited ground does not even need to be the main reason. So the onus of risk shifts, and the employer is basically guilty until proven innocent. So This does not mean you can never discipline or terminate an employee with a protected characteristic, right? But as the action is only unlawful if taken because of a prohibited ground and they can prove so. So, you know, what I'd like to reference here is that we're not saying that you can't ever terminate an employee or you know, counsel them or give warnings. You just need to ensure that the reasons for doing so isn't going to end up either being an unfair dismissal claim or an adverse action claim, which can have significant penalties and you know, cause massive liabilities and disruptions within a business. All right, a little bit about bullying and harassment. So the financial cost of bullying to Australian businesses is up to $13 billion per year. Policies and training is really important to ensure that you're meeting your vicarious liabilities to train your employees that bullying and harassment in the workplace is not acceptable. You know, I'll give you some examples. So bullying includes being aggressive or intimidating, you know, bad language or rudeness directed towards another worker, teasing, practical jokes, exclusion from team activities, or, you know, unreasonable expectations of their work, whether too much, too little, or withholding information in order for an employee to complete their work successfully. Bullying, on the other hand, does not include genuine disciplinary procedures, proper performance management, giving constructive feedback, and directing how employees do their work. So one way of preventing workplace bullying, as an employer, you are obligated to take steps to prevent or minimize the risk of bullying and harassment at work. So it's really important that you have a clear bullying and harassment policy in place, and it is practical to offer bullying and harassment training regularly so workers can understand the policy and there is no room for confusion. So bullying at work is a serious matter, and it is important to understand what it is and how to stop it. Bullying is repeated unreasonable behaviour between a worker and a manager or between co-workers, which creates a risk to their health and safety. So bullying and harassment actually fits under the Health and Safety Act of Victoria, however, then becomes an employment relations issue when it arises. Okay. All right, so just a very, very quick case study here. So, you know, we won't get into the actual, you know, I won't get into the bits and bobs about it, but there was a dental practice investigated by the Fair Work Ombudsman. The particular employee was engaged on a 457 skilled worker visa. They weren't paid the correct hourly rate under the Health Professional Award, so they were underpaid, and they weren't also receiving the correct overtime rates. The Ombudsman also found that the employer had failed to meet its obligations with respect to providing the employee pay slips, that none were provided, and, you know, the annual leave entitlements were also breached. And, you know, this particular case study hasn't been finalised, but possible penalties are to be faced by the employer and the business as the Ombudsman continues to investigate. And the dentist is allegedly claiming that they were underpaid by $66,000 throughout their employment life cycle. So, you know, when it comes to breaching the awards, especially with respect to underpayments, they can be very costly with back payments, and there's also significant penalties that an organisation or an employer may face for actually breaching the provisions of the award. So when we're looking at the employment relations framework, you're looking at, you know, am I paying correct? Well, first of all, am I actually using the right award within my industry? And is it covering the occupations that I'm engaging with in it? From there, what are their classifications? What are their minimum hourly rates? How much do I need to pay for Saturday and Sunday work, public holidays? What specific allowances are these employees entitled to? Then you've got contracts of employment. Not having those or having any policies and procedures opens you up to risk. And then you've got, you know, the day-to-day running of difficult employees in the, well, not day-to-day, but at least the difficult situations that you may find yourself with respect to managing difficult employees. are you disciplining or terminating them in line with the Fair Work Act and following a fair and due process in order for you to also not be exposed to any potential further risks and liabilities. Okay. All right, so that concludes today's presentation. I thank you all for your time. I thank you all for your questions as well. Have a great evening, everyone. I will pass you on to Richard now to finalise this webinar. Thank you.
Thank you. Thank you very much, George. Much appreciated. So, folks, that pretty much concludes the end of our presentation. The primary objective out of the seminar was to really give you an opportunity to understand your obligations, responsibilities, best practices, especially when it comes in the industry of the dental practices. So the organisation we represent provides a complete workplace solution for business owners, empowering you to be successful by making sure your work practices are fair and safe. You'll see on the slide in front of you right now, there are 4 core services behind what we do. And I'll just get you to, sorry, George, can I get you to refresh the page, please?
Yeah, do that now.
Okay. All right, thank you. All right, so the 4 core services is pretty much what we go to market and we provide our clients. And before I go into this, I just want to let you know we do have a strategic assist partnership with MW Partners. So if you're a client of MW Partners, we do provide clients of this organisation access to advice, anything to do with workplace relations. At the end of this presentation, you'll see my contact details, so you're more than welcome to contact me if you've got any questions. Just so you know, we do have a complete service that provides 4 core areas as one solution. If you were a client of EmploySure, we basically provide the service by, first of all, bring you up to compliance. And what that basically means is meeting your obligations. Our consultants will review your workplace practices, identifying any specific gaps and solutions. And based on the review, we provide you best practice tools, lay the foundations, ensuring you have a safe and fair workplace. And that includes documentation such as contracts, policies, procedures. And part of our compliance process is to also provide you guidance on the best approach to embed these practices within your business and ensure that there's no issues with non-compliance. So we've covered a lot of ground through this presentation. Staying compliant is one thing, having the right framework is the other. We take the headache out of that. We provide that one-stop solution by doing it for you and keeping it up to date. For all our clients also, they have access to an advice support service any time of the day or night. So if you have any queries, like some of the questions that have come up in this presentation, you do have access to receive unlimited proactive professional employment relation advice, as well as work health safety advice whenever you need it, and that's day and night. So the compliance piece and the advice piece is unlimited, uncapped, as much as you need, and we provide you that support so we can allow you to focus on running your business. Now, where we really make a difference is we give clients a peace of mind in ensuring they're protected, and that's through our insurance that's underwritten through QBE. It's part of our solution, one of our core services, and that allows clients to be protected from the financial burdens associated with claims, covering things like legal representation and, if required, compensation payments. Now, I can confidently say this, that no one in Australia provides this level of protection. There are generally 3 key things businesses want to achieve when they engage with us. They want to be compliant with Fair Work and WorkSafe. They need a framework that's tailored to their business so their staff know exactly what to do and what not to do, and allow them to manage them up and get the most out of them. And if they're not right for the business, strategically out. But the third most important thing, and that aligns with this core service, is what happens if something goes wrong? Who's faced with that burden? And this insurance policy provides that level of peace of mind where we can cover you against those financial burdens. And last of all, representation around claim support. So in the event, if there was a claim against your business, We have our own internal legal team, Employsure Law, and our in-house specialists will advise you through the process if a matter proceeds to court, and they can provide you the professional representation you need. So just to summarise, folks, it is quite complex out there, staying up to date with ever-changing legislation, but also running a business. We've gone through a fair bit of the content today. Our solution provides you basically a complete one-stop shop. If you have any concerns, any requests, we do all the work, we keep you up to date, and more importantly, if something goes wrong, we back what we say. I'd like to thank George and Michael for taking the time to present, and also Albert at MW Partners have the opportunity to present to you today. That concludes our webinar once again. George, if I can get you to please just go to the very last slide, which has my details.
Yeah, that's done.
Okay. All right. So my mobile number is there. If you have any questions or would like to reach out to me, it's 0499 499 692. If you'd like to discuss things off record, more than welcome to have a discussion with you. For those that have attended and registered the webinar today, we're also opening it up to have a complimentary meeting. If you'd like to see me one-on-one, have any questions, want to discuss our services further, you're more than welcome. And for any of the people that view this file in the future, you're more than welcome to reach out to me, and we can extend that opportunity to you also. So thank you once again. I hope you have a great evening, and I hope you've got a lot out of today's session.
Thank you to George, Richard, and Albert for your presentation, and thank you to everyone for attending the webinar. If you haven't done so already, please fill out the survey which is on your screen now. We thank you in advance for your feedback and wish you a good evening.